Don't forget to subscribe to Basement Tales. Just go on Apple, iTunes, or wherever you get your podcasts and hit that subscribe button. We release a podcast every Thursday. That way you'll be sure not to miss an episode. Welcome to Basement Tales with Sam Jackman, Charlie Einsman, Ed Grass, and Sandra Delancey. We have fun telling crazy but true stories about turning the worst possible property disasters into bags of money. Along the way, we'll pass along some important lessons to help you make cash on real estate. Sam and Charlie walked away from cubicle hell 25 years ago. Starting with no property, they created their own Clear Sky group of companies, sold hundreds of houses, bought dozens of rentals, and made millions in hard money loans. I'm Ed, a big firm litigator until muscular dystrophy made me find a hobby other than suing people. I miss it. Sandra's the normal person here with a real job plus some rentals. Her decades of friendship with the group, from office flunkies to property gurus, might help keep us all humble and focused on learning something. I wouldn't count on it.
We've got a pretty good one today. This one is topical. It happened this week and it's legal. And so it's a perfect one for you.
It's a legal issue or it's legal like you haven't broken the law?
We haven't been involved in the law breaking, but there are accusations that others have. And it goes to real estate law. Real estate law.
Real estate laws scare me. They're very complicated usually for no apparent reason, honestly.
So we have a client and they're in Arlington, Virginia. We won't give away his name. And he's been a client in good standing. He has a loan that he used to fix up a property on his investment house, and he put his property for sale. Everything looked good, almost.
Yeah, the house is in Alexandria. He lives in Arlington.
Yeah, I'm sorry. Yeah, thanks. He's in Arlington. He is physically in Arlington. And to understand really what's going on, we went and met with him in person at his home. Charlie, what did we find?
We found a house that we thought was going to be worth $2 million. It might be worth $700 in its best day.
That's his personal house you're talking about?
Yeah. The one we've got the leverage on is normal investment house. He has maybe 150, I think, on a house.
Well, we're a second trust, 150. House is worth about 575. He's paid the first trust down to like 40 grand.
So yours was mostly like a repair loan. Basically, he had enough equity.
That's all it was. Yeah,
repair.
Exactly.
Yeah. I mean, so far so good.
Yeah, really good actually.
So then he gets to the end of the maturity term, and he's trying to sell the house, and he's a little resistant to paying extension fees. But it seems more than that. And then the house goes off on sale, it goes off the market, and it goes actually to a rental listing status. And then we're pressing to like, hey, the
refinance.
Your maturity is up as of 3 days ago. So we went out to meet with him and to understand, because he's trying to explain things to me on the phone about a trustee. A trustee? What are you even speaking of? I can't. Well, there's a little bit of a language barrier, but there's also a concept barrier. But we got to the bottom of it. Charlie, what did we find there?
Well, no, we had a pretty big language barrier, even in person.
Yeah, we had a mask barrier. He was double masked, and with a language barrier, very hard to.
Well, I thought by language barrier you meant that the paying you money language.
Oh, that was clear, and he didn't like that language.
He didn't like that language.
No, but that wasn't the core issue.
But what kicked this whole thing off was the fact that we have automatic extension language in our promissory note, right? So we have a deed of trust, which is recorded in the local county courthouse, which tells the public we're, in this case, second trust holder. And then we have this promissory note. And so the promissory note defines the extension. And so in this case, it was a 150 second trust, and he'd been paying 12 straight months. And then he got to the end of the year, and of course he didn't. He wasn't excited about our 3-month extension fee, which, oh, by the way, was probably 5 points.
Well, it's expensive, but this is, and I think the listeners need to know, that the product that you're putting out is designed to, and I assume this is the right with this one, to fix something up and sell it quickly, so that the new buyer will get a regular loan at the local bank, or in this case, if he wants to rent it, he could do that. But it's not good to have a hard money loan for that.
No, and he only switched. Yeah,
you want to get a regular investment loan to come in and then rent the place out.
Right.
But he only switched to renting it because he couldn't sell it. And the reason he couldn't sell it, it's burdened with a title issue.
Oh, I was going to say the price was too high, because you always tell me, Sam, if it's priced properly, it'll sell quickly. Yeah, well, I guess there's other issues, like if it has rats in it, or that kind of thing.
Priced properly, you could sell rats.
No,
this
right.
Is true.
We thought it was
rats.
But we thought it was priced pretty good. The only problem was we just weren't sure why it took him a year to finally get the house on the market. So what happened was, when his loan expired, and this was, I think, July 31st of this year. So as this podcast will be put out there, that's almost 5 months ago. And so he then called me up and was arguing with me because he wanted to try and negotiate the extension fee language in the promissory note. And so, me, I wasn't interested in negotiating anything, because it extended it to September, October, and November 30th. So it extended it for 3 months. And so that language was already in there. So I'm telling him, like, look, we're not going to negotiate something that's already in the language. We're not doing it. That's your 3 month, extension. It's in the note, and you've got now a 15-month loan, because originally it was supposed to be a year, but honestly, we should have been paid back 6-9 months ago.
Well, because your risk and your cost goes up on these. The longer, given that 3 to 6 months, they should be able to fix and flip whatever they're doing. If you're at a year and then going to 15, it's like, there's a problem. Meanwhile, you don't have your money to loan out again, and so it sort of encourages them to do what they're supposed to do. Yeah.
Right. So then we're discussing it back and forth. And he hasn't made a payment in probably 4 or 5 months, because
it's July, the end of July.
Yeah, he might be upset with us, but that's okay. So then he sends Sam, because we're going back and forth. He sends Sam an all caps email. Right.
All caps emails are just not good.
Right. Yep. And so then he's saying something about a family emergency, something about this, something about that. And then Sam had the bright idea that we needed to go out and meet him, because he's talking about the reason why he can't sell his house. There's a Liz pendants on the property, which you might want to explain that.
Yeah. Well, I'll break in and say, so now we've got a title issue. So was the Liz pendants after your note?
Yeah, way after. As a matter of fact, the Liz was 2 months prior to today, 3 months prior.
So basically, for the listeners, a Liz pendants is basically a notice on the title that somebody is making a claim to the ownership, or in some fashion that the property should not be sold without you being aware that this suit is going to affect the title. I guess pendants must be pending, but that's the standard language. And so now we've got a first trust, a second trust. Normally, whoever buys it would pay those off, but since there's a Liz pendants, any buyer is going to be concerned, depending on what the circumstances are. So, all right, now he's got a Liz pendants. Now you got a problem. So what happens from there?
Right. So the basic Liz is the fact it's a breach of contract lawsuit. Right. He had the property. He was supposed to sell the property to some investors back in 2018, and they kept extending the contract for 9-10 months after they were supposed to close, because of what he is describing as a title issue, that he can't properly convey the property.
And so he couldn't pay off the first trust. Is that right? He couldn't pay off the first trust that he had on it.
We couldn't follow all that, because what had happened was the owner had purchased the property in 1981 under his name, right? We'll call him, for simplicity's sake, PM. So first name P, last name M. All right. Then what happened was 34 years later, no, actually 34 years later, this property went from his personal name, PM, to a PM Realty Trust, which we don't really know exactly what that is. So in 2015, this Realty Trust owned the property. Well, he bought the property from the Realty Trust.
The current owner.
Yeah, the current owner, who we'll just call him GPW.
How about John? How about we call him
GPW?
John?
We want to call him GPW. It could be John. Yeah, John. Perfect. John. John means many things in many languages. John has very many first names. So my guess is John is actually the correct name. All right. So John buys it from PM Realty Trust. PM Realty Trust holds a first trust on the property, right?
So it was like seller financing is what
that's
you're
exactly
saying.
what it was.
Exactly.
Yeah, it was seller financing from a trust. All right. So then this company, these investors go to buy it from John. So John buys it for $215. These investors in 2018 offer him $290 to buy the house from him in 2018. And so John signs off on the contract because evidently back in 2018, this was probably a pretty good deal, right? But mind you, this is before we put the second trust on the property. We didn't know anything about this. Well,
you're thinking it's just for the listeners. I mean, seller financing is just basically whoever had the property, they're saying maybe they get a certain amount of cash and then they take a note like they're the bank, and instead of the buyer going and getting an actual loan. So that's a pretty common thing to have seller financing. But then so the first one sells it to the second one with seller financing, but the second one sells it to the third person with a contract, and then it sounds like something goes wrong.
Well, that's where we're not sure what went on. So what happened was he bought the property for $265 in 2015. The seller held a first trust for $215, so he put down approximately $50,000 as a down payment.
Mm-hmm.
Okay. Fast forward it to 2018. New buyers come in, investors come in and buy it from this guy. They buy it for what, Sam? About $290. All right, so they're under agreement to buy it for $290. John is telling us that he can't properly convey the property because there's something wrong with the trust, and we couldn't really follow that, right? Because we don't have the trust documents. Okay, so now fast forward it to 2020, July of 2020. We then put a second trust on the property. We know fully well that there's a first trust, right?
And we don't have any knowledge of a problem related.
Right, we have
just
no
figure
knowledge.
it's a standard seller financing thing. Yeah. And you see the notes recorded, I assume. There's a deed of trust.
And we had a normal, we had a normal title search done and a normal title insurance that we have for our second trust of $150. Now, needless to say, John has been paying on the first trust. As a matter of fact, he's been prepaying it. So the $215, he's been paying this guy down to about $45,000. That's probably what he owes today. And now the house is worth about $575,000, $600,000 because of our market run up. Okay.
Well, and his renovation. He renovated it.
Right. And he renovated it. So now September 2021, that's when these guys filed the lawsuit of a breach of contract back in the 2018, 2019 timeframe. And they're all mad because of the run up of the market. So now,
but
John,
why didn't they close on the property sooner? Oh, because of the title issue with the original Realty Trust?
Yes, that's what he's saying. That's what John's saying. John is saying that there was a problem that the trust wasn't correctly signed. And we don't know what that means.
There was no one to sign it. The trustee had not been assigned to the trust by the courts in the entire time frame that he was trying to sell it. And so he needed a physical person to sign off on the sale of the property so he could pay off the first trust. Therefore, since he couldn't get a payoff, he couldn't interact with the trustee, he said he couldn't close with clear title. And then he requested a release. This is something I'm familiar with, and Charlie as brokers, agents, you have to get a release when something doesn't work. All parties sign it and the EMD is returned. In this case, the parties that owned it were the parties that were buying it were two LLCs from John. Those LLCs, one provided a release, one did not. The money stayed in the broker's escrow, so the contract was never released. And so now the people saw that the asset's worth so much more and it's on the market. Years later, hey, all that equity growth is mine. They were demanding him pay $310,000 in equity growth, the difference between the asset value now, list price, and the purchase price, not even considering that he renovated it or that their contract wasn't valid or whatever. So they filed a suit to extort some money from this guy, and he's not too sophisticated. He did hire an attorney. The attorney wrote a response, and it was childish type response. Basically said, "Look, we're not guilty of anything. We don't have anything to say to you. Go away." So basically, they're bringing it to a head in a courtroom setting.
They filed suit.
They filed countersuit. The first people sued, and he provided not countersuit, but he filed a response to the complaint.
Right. So the people who went to buy the property from John, you said that was two different LLCs?
Yeah.
They were investors. They were gonna fix and flip it.
So they said basically, I'm A LLC and B LLC, and we together are buying the property from
Correct.
John. A LLC gave a release.
Correct.
Because he must have said, I can't convey title.
Yep.
Like the contract says, I give you your EMD back. But B LLC never released the contract. And so they basically have a breach of contract claim.
Yes.
And what they're asking for is probably either cash, but because they're doing a lis pendens, you can sometimes in real estate get specific performance.
They don't mind either way. Yeah, but
exactly.
they've asked for
cash.
A prayer for a relief of cash as they've been praying for.
Right, because most cases get reduced to whatever the damages are, but in some cases, if it's a unique piece of property, or you argue that, or you have trouble disputing the value, you can say, "Look, I have a contract to buy that house. You have to convey that house to me." And then you, as a backup, you say, "Okay, you can't because of whatever title problem, and I can't fix the title problem. Therefore, give me the money that I lost, the $300-some thousand." But so that's all. But I want to know what happened with this whole realty trust. Is that thing still up in the air?
No, the trustee has been assigned, and as of this year.
The guy. Well, then the guy. Once the trust was formed, the guy died after the trust was formed.
But the trustee is in place now, assigned by the courts as of this year, early this year. So now he could convey title if he didn't have a lis pendens sitting on his property for not conveying it the first time.
Right. Yeah. Well, it's interesting.
It's a mess.
Well, it's interesting for you guys too, because in a sense, when they were looking at the title, everything looked appropriate. The guy sells it to the realty trust. Realty trust sells it to John. John has a seller finance, and you guys come in as the second note. Everything seems fine. But what's interesting to me as a learning thing is, how would you know that there was a problem with that realty trust, that there's nobody to sign? I guess that's some of the risk with a seller financing. I mean, even say it was some dude who just died, and now that loan is stuck inside of his estate. You got to go to court and get somebody to say, yes, I got all the money that's owed. Here's your release on the property. And it sounds like there's really, I suppose one thing you guys could have done is you could have, but I mean, it seems like an awful lot, say what's going on with this realty trust, but I don't know. Is there anything you could have done
extraordinary step? Yeah. That'd been an extraordinary step for us.
Yeah, we wouldn't have had any reason to do that, because we just cared about the bring down to the time he took title of it.
I mean, we're still protected right now. We could take it to auction, and this lis pendens doesn't stop us from our foreclosure interest on the property. They can settle that later. So, in a sense, we've been protected the whole time. We wouldn't want to have him if we had known anything of this. We would have never. We would have advised him early on for a resolution and not fix it first. Yeah, but he left a brokerage thing just hanging, out there, and that the broker has some duty to make sure that things don't linger for like years on end like that. They should have engaged themselves in being responsible for their clients, both on both sides, to bring it to an end so it didn't come to an end like this.
They just never finished up the paperwork because presumably A, LLC released the contract. B probably would have, but it just sat and everybody
B
went
was
on to something
grumpy
else.
about it. B wanted him to perform, so B was arguing it all along. Well, but didn't take any action until he saw it come for sale.
Yeah. And so John, the mistake that John made is he poured $150,000 of renovation and time and effort on a property he might not own. I mean, because these other people with the contract, there's probably some issues about would they have would he have a claim at least to get that money back? I don't know. That gets pretty complicated.
Well, I don't think it's as complicated if they used a standard board contract, and they did. I looked at it. So in these circumstances, in the ordinary course of real estate, the sale has passed the settlement date, and the seller couldn't convey title to the property. And so the normal reduction of the damages in that sort of circumstance is the escrow, the deposit. That's
right, because the contract just expires.
Yeah, this contract expires. They can't execute it. He can't perform on it. So he's not really in breach. He didn't know when he started that process that the title was not clear. He's not obligated to at all costs clear his title.
Yeah, but he's still in breach of contract, isn't he? Because it says in the standard contract, I, owner, am going to convey clear title to you in return for $300,000 or whatever it is. But he breached that agreement. But the damage
for I think the contract
is a liquidated damages provision.
Liquidated damages. I have to look at his. Maybe his doesn't, but generally speaking, they have liquidated damages for like title issues to the earnest money deposit.
Mm-hmm. And literally just the return of the deposit.
Mm-hmm. Yeah.
But probably what somebody might claim, they might say that it was fraud, right? That he knew, and therefore you have technically fraud can be a non-contractual claim, right? So sure, the contract limits the damages for breach of contract, but this was a whole separate fraud. Again, I don't know that it is.
They didn't claim that in their lawsuit, but that may have made it better. I thought that would be a better claim than this thing that they're trumping up now.
Yeah, but I mean, fortunately, incompetence is not fraud. I mean, if you or good faith mistake, right? How would you know about this trustee problem?
You wouldn't. If I had taken under financing of that, I wouldn't have known about that problem.
Right.
I mean, that is not in the normal course.
It would seem like it's not that uncommon, though, for, like I say, if the original owner who took a note, what if they died? The note becomes
That's the issue.
Part of their estate, yeah.
So, the LLC the owner died.
Goes away, yeah.
After he could sign for it. He died after he did everything. But then then he didn't have a surviving person, or for whatever reason, the courts needed to appoint a trustee, and he didn't have a trustee appointed in his trust. And so that took several years. So then there was this period of time in which it was like in a suspense state. And if the guy had been really aggressive, maybe he could have taken the thing to court at the time he was trying to sell it and asked the court for relief so he could sell this thing. And on an emergency motion, he has a smart lawyer, he figures something like that out. But he didn't know to do that. And he just didn't know. Otherwise, he would have, because he wanted to sell it. He listed it for sale and signed a contract.
Right. It sounds to me like you'd want to do a quiet title action to say, all right, the first note, say there's 50,000 remaining. Here it is. Here's the 50,000. And this trust is not around to pay it. Or to sign off on it. So, hey, court, issue a thing saying I've got clear title, and put the money in the court registry until they get around to getting a trustee. But one of the problems is, who do you serve? Who do you sue for the trustee when there's who do you name? Where do you serve process? So it could be difficult to figure all of that out. Well, my takeaway from all of this is be careful about owner financing, not so much for what you guys do, because you're protected with enough equity that if there's a problem with the first trust for any reason, and you can have regular bank trusts that aren't paid and have attorney's fees, but as long as you have enough equity, then you're safe. And you guys don't do as many second trusts, right? Partly because
no, we probably have like 2.
Yeah, we try not to, but I mean, if there's such a huge equity cushion and there's, the first trust we thoroughly understand and it's not really big and looming, then we'll do it. Now, first trust is, let's say the property is worth 1.5 million and they have a first trust at 800,000 and they need 100 grand. Then I doubt we would do it, because that first trust being at whatever, I mean, it could get really haywire really fast in case of a default, and we could get absolutely slaughtered on the second. So it just depends on that first trust versus the equity. Yeah.
So overall, I mean, we wouldn't want to do this deal again, but we wouldn't have a way of stopping it from happening again. It's just,
I don't know. We would
something come up in the road.
But I don't know. I mean, if it's worth 550 and he owes 150 on it.
Oh, I just don't want him to be caught up in a situation where he's not comfortable. He can't pay, whatever. He's not.
But this guy had been paying for 12 straight months.
Yeah, no, but he was ready to sell it. I just want to see someone stuck.
Early.
I want to see someone stuck.
Yeah.
This poor guy was stuck, and it was ugly.
Yeah, poor John. Poor John.
Well, it sounds like it was good faith on his part. I mean, and unless maybe he knew there was a problem with the first trust, but he probably thought, well, whatever, we'll fix it. No,
I don't. This guy did not know there was a problem.
And by the way, his name is Dr. John. I mean, he's a very well-educated guy.
Yeah, he's not an unsophisticated.
He's definitely a lot more educated than I am.
Yeah. Well, that's a big warning sign, though, for all of this stuff. It's like, people look, I'm a lawyer, right? So you start to think, well, I know some stuff. I know these fancy Liz Pendens and quiet title, and I got all these degrees. So I'm going to go open a restaurant. Well, if I went and opened a restaurant, I would be in deep trouble. First of all, I eat all the food, not pay for it. But second of all, I don't know how to run a restaurant. I mean, maybe I'm smart enough to learn, but more likely it would crash and burn. And so it's you have to be cautious if you're fixing and flipping. There are things that you could be a freaking genius that you just wouldn't know. You get caught up in unless you listen to our podcast and learn all these things, I guess. And
there you go.
And read up and, hit like and subscribe. That kind of thing.
Subscribe. Be careful of seller-held financing. Make sure you know what you got.
Yeah, don't want a nightmare.
Yeah, and then if you are a seller that has financing and holding it, call us up. We'll buy it.
There you go.
Yeah, that's true. Well, that actually, I already said the like and subscribe part, but yeah, you can buy notes like that too.
Yeah.
And sometimes those can be pretty nice. Somebody else took care of all the trouble originating it, but of course, here the trustee wasn't around to sell it. So interesting. All righty. Well, that's it for today.
It's a wrap.
We'll be back for another horror story next week.